Hey guys, welcome back to my channel, Down the Rabbit Hole News. I am the Rabbit. Listen, we have to talk. Last night, there were some late night submissions. We were live. We did a quick little video yesterday that I uploaded. Make sure you check it out. I actually started a whole playlist because there's going to be the coverage of the trial, but also like little mini videos to kind of keep you up to date about what's happening behind the scenes. So we're going to get to that. But yesterday, Douglas Wigdor submitted a letter to the court basically asking for the court's permission to be able to be a support to his client, Cassie Ventura. Now, Cassie Ventura and Douglas Wigdor worked together during the lawsuit against Diddy, which was settled in less than 24 hours. So now the government and Diddy's lawyers are responding to this request, okay? And they're kind of going about it this way. Let's get into what the government said about Cassie having a support or talking to her lawyer during breaks while she's being cross-examined and while she's giving testimony. Let's get it. So really briefly, the government writes this letter to the judge. The government respectfully submits this letter in opposition to the defendant's request that witnesses be prohibited from communicating with their attorneys during breaks in cross-examination. In making this request, the defendant cites no holding that third-party witnesses should be prohibited from speaking with their independent counsel during breaks in examinations. Okay. So there's a bunch of citings of cases that they do for this argument. But where we get to the meat and potatoes of the government letter is it says, during the limited time it has had since the defendant first made his request, the government has been unable to identify any case in which a third-party witness has been prohibited from speaking with her attorney during cross-examination. By contrast, the government has identified multiple cases in which judges in this district have denied similar defense motions in criminal trials seeking to bar witnesses from speaking with their attorney. The court should decline to issue the defendant's proposed far-reaching order prohibiting witnesses from speaking with their own independent counsel. This is what the government is saying. Okay, so it sounds like the government is in support of Cassie talking to her independent lawyer during breaks or whatever. The defense has made no showing whatsoever that any third-party witness has or intends to use her attorney to circumvent sequestration. The court can address any concerns the defense may have about such circumvention by following Judge Furman's example in Avenatti. And permitting the defense to question witnesses about any conversations they have about their testimony during breaks, which should cover any attempt to circumvent sequestration while preserving the witness's ability to have privileged conversations with their attorney. Indeed, there's a good reason in this case to allow witnesses the ability to speak with their own attorneys, given that much of their witness testimony in this case will cover extremely sensitive subjects, will include witness descriptions of their own involvement in potentially illegal activity. And with respects to witnesses who have engaged in civil litigation, will touch upon potentially privileged areas. With respects to the victim witness, permitting consultation with counsel is consistent with the spirit of the Crime Victims' Right Act, which places limits on the court's ability to sequester victims. Although the government consent to sequestration of victim witness after conferring with defense counsel, the government objects to stripping victim witnesses of their ability to confer with counsel during this trial. Such an order would not only risk intimidating victim witnesses by preventing them from receiving emotional support from their counsel, but it would also risk creating a chilling effect on the willingness of other victims to testify at trial if they can be prohibited from seeking the support of their attorneys while being cross-examined by attorneys for their abusers. Ooh. This is what the government wrote. Should the court nevertheless consider issuing such a sweeping order, the government understands that the counsel for at least two victims wish to be heard on the matter. Specifically, counsel for Cassandra Ventura and counsel for the victim witness testifying under the pseudonym Mia have asked that the court allow them to be heard before prohibiting them from speaking with their clients during cross-examination. The government hopes that time need not be wasted on such briefings and arguments because there's an ample reason to deny defense requests without further proceedings. All right. So then, of course, Diddy's lawyers have to respond by Alexandra Shapiro, who's the other attorney there for Diddy. And she writes on her letter, which is shown here. Dear Judge, we write in response to the government's and Ms. Ventura's counsel's letter concerning the propriety of counseled consultations with witnesses while they're under cross-examination. The reasonings, and they cite case there, and they cite a case there for their reasonings. The court should order witnesses not to communicate with any third party regarding their testimony, including their attorneys, while under cross-examination. While the holding of Perry does not require the court to instruct witnesses one way or another, the Supreme Court's reasoning is clear. It is simply an empirical predicate of our system of adversary rather than inquisitorial justice that cross-examines of a witness who is uncounseled between direct examination and cross-examination is more likely to lead to the discovery of truth than is cross-examine of a witness who is given time to pause and consult with their attorney. So basically, they're saying that the art of cross-examination is really that, instead of pausing so that the witness could consult with her attorney. I know I got some attorneys watching this. What do you guys think about that? Now, I know I'm like completely not briefing it in any legalese because I'm not an attorney, but that's how I'm interpreting this, okay? So you guys let me know and correct me, attorneys, in the chat if I'm getting this wrong, okay? The government states it has been unable to identify cases ordering witnesses not to communicate with their attorneys while being cross-examined, but courts in this district and elsewhere have repeatedly so ordered. So they cite another case there, okay? The concerns raised by the government and Ms. Ventura's counsel are no reason to hold otherwise. First, the defense does not request a total bar on all communications. We do not object, for example, to communicate about a witness' health or correspondence concerning trial logistics. Rather, the request is to instruct witnesses not to confer with third party, including their counsel, only on the substance of their testimony. To be clear, that prohibition would include any communication regarding testimony concerning Ms. Ventura's civil lawsuit against Mr. Combs and the settlement in which Wigdor LLP represented her, as that lawsuit goes to the heart of this case and Ms. Ventura's credibility on key issues. It would be wholly improper to allow Ms. Ventura to consult with her counsel on such a central topic or any other topics relevant to her testimony while on cross-examination, as the defense would not be able to fully explore such a conversation on cross-examination given Ms. Ventura's attorney-client privilege. Permitting the defense to question witnesses about any conversation that they have about their testimony, as the government suggests, thus in no way solves the problem. This is yet another reason to forbid consultation about the witness testimony while under cross-examination, as it permits a witness like Ms. Ventura to invoke privilege as a sword and a shield, which is likely to occur here given her counsel representation in the letter. Should a witness attempt to hide behind a privilege, unduly restricting cross-examination, the witness direct testimony may have to be stricken. Third, the government suggests witnesses will need emotional support from their counsel and advice concerning extremely sensitive subjects, such as the witness's descriptions of their own involvement in potentially illegal activity. But that is precisely the type of consultation that Perry is citing another case, suggests is likely to undermine the discovery of the truth. Okay, this is interesting. The discovery of the truth. So if they need counsel because they might have engaged in a legal activity, and this is just an example, okay? Say that, example, totally not true, but just an example. Say that Cassie engaged in any kind of illegal activity while she was engaging with these, FOs. And I'm thinking of like, what would that be? Say soliciting minors to engage. That would be self-incriminating there, right? That would be a need to kind of talk to her attorney about that. So I kind of see that being the issue and a need for Cassie to have her counsel. But at the same time, Diddy's attorney is saying, well, that is like the spirit of this cross-examination is truly to get to the truth, the discovery of the truth, right? Let me know what you guys think in the comments. The government's suggestion is not just to grant the witness an opportunity to regroup and regain a poise and sense of strategy, but to actively encourage it through coaching of these sidelines. And a lot of you guys have been throwing this word out, coaching. And some of my wonderful attorneys have said, well, what's wrong with coaching? I guess I have to ask that. For those non-attorneys, what is wrong with coaching? What do you guys see in being the issue? And how do you determine somebody has been coached? We're not there. Half of you guys that are watching this are probably not there. Actually, I would probably say a good 90% of you guys that are watching this video are not there. What do you consider to be coaching? Let me know in the comments what your thoughts are. Okay. And that is why, finally, the Crime Victim Rights Act instruction that victims be treated with fairness and with respect for the victim's dignity and privacy does not speak to the instant request in any shape or form. Dignity and privacy are separate concepts not implicated here, and the right to confer with counsel throughout a victim's testimony is notably absent from the otherwise long list of protections afforded to victims under the Act, which cannot trump the constitutional rights of the accused in any event. For the foregoing reasons, the court should order witnesses not to communicate with third parties regarding their testimony, including their attorneys, while under cross-examination. Oh my God. Guys, let me know what you guys think of both arguments. What do you guys think? Make sure you guys check us out later because we're going to be live covering the trial as well. But tell me what you guys think in the comments. This is just a preview of what's going behind the scenes with these attorneys. And I'm not an attorney, but I'm here to report what's being said and what's being put out there. I'll see you guys on the next one. And please check out our playlist of this whole trial while we're covering it. Also, we have received the first day of transcripts for this case, for the Sean Diddy Combs trial. We're going to talk a little bit more about those transcripts in the live stream, which is amazing. It's going to really get us to the nooks and crannies of what the arguments are. I'm all here for it. I'll see you guys on the next one. Hit the like button. Rabbits out. Bye, guys.